arbitrary and beyond the board's decision. Now, in the matter of Crown Ribs application, if the board were to impose an increased setback, which obviously the applicant couldn't meet, and did so without some substantial nexus or circumstantial need for the increase, I believe that decision would not pass muster with the circuit court. The standard of review, as I've already indicated, is by way of writ of certiorari. That type of review concerns two things. Number one, whether the board had jurisdiction over the matter, and two, whether the board pursued in a regular manner the authority conferred upon it. If this board's decision rests on the opinion or belief that the Board of Adjustment should, just disagrees with the ordinance and is influenced basically by the neighborhood, I don't believe that either prong of the certiorari of standard review would be met. We'll talk about conflicts of interest now. The standard that appears to apply to all public officials is set out in SDCL 6-1-17, which says, no county, municipal, or school official may participate in discussing or vote on any issue in which the official has a conflict of interest. The official shall decide if any potential conflict of interest requires such official to be disqualified from participating in discussion or voting. However, no such official may participate in discussing or vote on an issue if the following circumstances apply. Number one, the official has a direct pecuniary interest in the matter before the governing body, or at least 2/3 of the governing body votes that an official has an identifiable conflict of interest that should prohibit the official from voting on a specific matter. If an official with a direct pecuniary interest participates in the discussion or votes on a matter before the governing body, the sole legal remedy is to invalidate that official's vote. As I mentioned earlier, there are different standards for determining what a disqualifying conflict of issue is in quasi-judicial proceedings and in regulatory or rulemaking proceedings. The standard for disqualification in a quasi-judicial proceeding is stricter than in a regulatory or rulemaking procedure. And I'm citing Northwestern Bell Telephone Inc. versus Stafford, and also the Armstrong case. The standard for disqualification in a rulemaking or regulatory proceeding, which again is legislation, is that the official should be disqualified only when there's been a clear and convincing showing that the official has an unalterably closed mind on matters critical to the disposition of the proceeding, which is a difficult standard to make or prove. The standard for disqualification in a quasi-judicial proceeding is that the official must be disinterested and free from bias or predisposition of the outcome, and that the very appearance of complete fairness must be present, which is a much broader, much stricter standard. The standard also says that where actual bias or even an unacceptable risk of actual bias or prejudice exists, the decision maker must be disqualified from participation. That's true because in quasi-judicial proceedings, due process is a very strict concern. It requires a fair and disinterested and impartial tribunal. Now, what are some examples of conflict of interest? The most illustrative case on this subject that I found was Haynick versus City of Winner. In that case, the court identified 4 different categories of conflicts of interest that would require disqualification. Number 1, direct pecuniary interest. and that's when an official votes on matters benefiting the official's own property or affording a direct financial gain. 2, indirect pecuniary interest, and that's when an official votes on a matter that financially benefits one closely tied to the individual or official, such as an employer or family member. 3, a direct personal interest, and that's when an official votes on a matter that benefits a blood relative or a close friend in a non-financial way, but a matter of great importance, such as in the case of a councilman's mother being in a nursing home that was subject to a zoning issue. 4th, indirect personal interest, and this is a big catch-all. When an official votes on a matter in which the individual's judgment may be affected because of membership in some organization and a desire to help that organization further its policies. Those are the 4 categories that you need to bear in mind. Now, how should we go about proceeding in the future, and how are those determinations made? And this is my advice. The board members should be aware of these different definitions, which I just stated, and each member on their own should disclose any conflict that might fit into any one of those categories. I'm not the conflict of interest police, and I don't independently investigate conflicts of interest. I will, when asked by a board member, give him or her my legal opinion. Then I leave it up to the board member to honestly assess the situation and to determine for themselves whether or not they should recuse themselves. However, any potential conflict should be made known to the entire board. If a member believes that he or she has a conflict, that member should recuse themselves, not only from voting, but any participation in the proceedings. If the member with a potential conflict does not believe a conflict of interest exists, the matter should be voted on by the board, pursuant to STCL 6-1-17, which I've mentioned. To the extent that the potential conflict does not result in recusal prior to the hearing, the potential conflict should be disclosed on the record prior to the start of the hearing. That affords the participating parties a chance to lodge objections or inquiries. What's the remedy if a member who has a conflict votes? The sole remedy is to invalidate that member's vote, and that may affect the entire proceeding if the remaining members no longer have a quorum or cannot reach a 2/3 majority as required. I want to just finish talking briefly about ex parte communications and quasi-judicial proceedings. First of all, what is an ex parte communication? It is a communication between a decision maker and an interested party outside the official channels of the proceedings. Examples would include receipt of mail from proponents or opponents, phone conversations, inspections, conversations, etc., which go to the merits of the decision being made. What should be done if an ex parte communication occurs? The communication should be disclosed prior to the start of any hearing. The disclosure should be made in the presence of the board and the public, and if possible, the content of the communication should be made part of the record. Does ex parte communication require recusal? If the communication is invited, then recusal should occur. An invited communication is a communication that's initiated by a board member. An uninvited, if the communication is uninvited, then recusal should only occur if the board member believes or feels that the content of the communication will not allow him or her to be fair and impartial regarding the matter to be decided. Those were the issues that I wanted to discuss with you, and I'd be happy to answer any specific questions from the board. I've covered a lot of ground.
That's a lot to soak up.
A lot of civics, a little bit of government, a little bit of separation of powers.
I'm wondering if we should have in print an actual, in our rules book, an actual, what would constitute a conflict of interest, or a policy concerning that, or?
That can easily be done.
You have bylaws, so we need to, we do address a few things in your bylaws, but nothing specific.
Correct. There are some things in there specifically as far as noting whether or not you have direct pecuniary, indirect pecuniary interest, and ex parte communication. But we could go further and at least define those in the bylaws for you if you'd like, based on what was presented here.
But it's pretty much up to each individual to bring it up, you know.
Yeah, it requires an, obviously an honest examination of yourselves and what interests that you may have. A particular concern are direct pecuniary interests. Other interests get far more tangential, and it requires to be honest as you can in terms of identifying that, disclosing it to the board, and if necessary having a vote of the board as to whether or not it fits into one of those categories. They say that everybody in the world there's only 7 degrees of separation from everybody in the world and Kevin Bacon. Now I don't know what that means exactly. In South Dakota it would probably be less than 7 degrees. But these conflicts of interest, they're sometimes difficult to understand and reason through. I know in preparing for this, my brain hurt trying to think of all the different aspects of it. But like I say, it's important for you to know the rules, to disclose those conflicts as they become apparent to you if you fit into any of those categories, so that there can be a record made of it. Again, one of the primary points I wanted to make is, when you're in your quasi-judicial function, where it's a contested issue and you're adjudicating directly on property interest or rights, that requires a fair tribunal. It's like being in a court of law. Its due process is very strict in those cases, and that's why the categories that I talked about are so encompassing and sometimes I think a little hyper-technical. As a legislator, we have hundreds of legislators that are in Pierre and other places that are teachers, they're farmers, they're members of industry, and they participate in committees and on pieces of legislation that they vote on that have a benefit to those, whether it be education bills, whether it be farming related bills or others. And I think that unless there's a direct pecuniary interest, or unless it can be established that individual has an unalterably predisposed or closed mind on that issue, they're not subject to disqualification. And as I said, you operate differently when you're wearing your Board of Adjustment hat than you do when you're wearing your Planning Commission hat, or when the county commissioners are wearing their legislative hat when they're promulgating or amending or considering changes to what the ordinance is. The point being, when I talked about the Hines case and some of the constitutional protections that are inherent in somebody's right to use property and reap the benefit of that property ownership, and balanced against the public's interest in promoting the health, safety, and welfare of its citizenry, the legislative body, which is the commissioners, are the party responsible for doing that. And they do that when they promulgate or create the ordinance to begin with. It's not your function to try to promote or legislate what you believe to be in the public's interest. Your job and your duty is to follow the ordinance and to follow the requirements and review applications to see if they meet or do not meet the conditions that are stated in the ordinance. Am I making myself clear on that point? I think.
Public Utilities Commission, they had a hearing on, I can't remember which one it is. they applied conditions on that permit that really were above board any planning and zoning even. And of course, they're not legislative, but yet they dropped the DBA to 40, and they dropped the flicker thing down to 15 hours instead of 30. And what's the difference between that acting board and this acting board?
I don't know, does the Public Utilities Commission, do they have some rulemaking,
They have promulgating, they have the ability to promulgate rules.
rules and that type of thing? You know, it's surprising to me in a way that many of our requirements that we have in our wind ordinance are really the same as what the Public Utilities Commission has
And
on that, on these things. Bottom line is, it's your responsibility to apply the rules and regulations as they've been adopted by our Grant County Commissioners, and not try to interpose or interject additional conditions that are unreasonable, which could be deemed by a reviewing court to be arbitrary or capricious, or done at the will of your belief that, doggone it, the setback just isn't big enough, or, you know, it's within the public's interest that it be larger or whatever. I think you can do that, you know, if there's some circumstances or there's some, you know, nexus to doing that, you know, like I indicated with my hypothetical on if it was, this wind tower thing was parked at the end of a runway or something like that, obviously there would be a great need that the setback would need to be increased. But you know, if you do that, you're going to be required to make the specific findings, you know, in your decision that you're going to have to be able to defend, you know, in lawsuits or on appeals that follow, because you'll be deposed, and, you know, so the decisions you make have to be, you know, they have to be supported. There has to be reasons and facts, particular to any application which would support any additional conditions. Todd, do you want to add anything onto that?
That's part of what, our, you know, part of what we do with all of the, you know, everything we're meeting on is making a couple of extra things that they need to meet to, because of where they're located at.
Yeah, that's good. That's what you need to do.
Yeah.
If it's unique to where they're located, and if there are some additional or reasonable conditions, you know, that would further the, you know, further satisfy some of the requirements of the ordinance, I think that's appropriate and fine.
the public testimony in a process like this really is, the way it's set up, doesn't really carry much water. Does it?
Well, to the extent that the public can bring information to you on matters that are relevant, you know, to the inquiry that you're making, you know, particularly, it's been my experience that at these public hearings, additional information has sometimes come forth that relate to, you know, like manure easements or different mistakes that may have happened, or different inaccuracies in the application itself, and the public can, you know, can bring that information forth. But to the extent that the public brings different concerns and issues to you that aren't a part of the rules and regulations requirements, I mean, they're irrelevant. I mean, it's not part of our wind ordinance that, you know, the development of this particular land use in this particular area cannot have a detrimental effect on the use and enjoyment of some other person's property. or that will lower their property values, or things of that nature. I mean, those are concerns, yes, but they're not concerns that you get to take into consideration as a Board of Adjustment. They are concerns that you can take into consideration as a planning commission, where your function there is legislative and policy driven and ordinance driven. You know, if you think that there's an area that's lacking in our ordinance, additional requirements should be in there, or certain requirements should not be in there, or other considerations should be taken into consideration. You can do that as a planning commission and submit your recommendation for those changes to the county commissioners, and they can adopt those. I mean, if it's the intent, I mean, if it's going to be policy in Grant County to not have wind farms, then propose a setback that's so great and so big that there can't be any wind farms. And if the county commissioners were to adopt that, I suppose that would solve a lot of problems. But that's policy, and that's up to the legislative body, which is the commissioners, to determine and set those rules based on what they believe is in the best interests, or the public's interest, in promoting, like I say, the health, safety, and welfare of its citizenry. If they believe that way, they can create a setback that's 2 miles or 10 miles. And if they do, that's fine. That's fine. They're the people that get to do that. They determine policy. And that's what they were elected to do. They were elected to make policy in Grant County. And having done so, having promulgated and adopted these ordinances in the 70s and on throughout the years, the changes that they've made, they reflect those changes in, I guess, the societal needs and the social needs of our county, and the fact that industry is changing and land use management is changing and evolving, and they've considered that, and they've come up with rules and regulations that now you as a Board of Adjustment need to follow. And I mean, it's a hard thing. I mean, on the one hand, you have many landowners that have a very that are very interested in this. Tons of landowners that want to, use their land the way they want to. That's why people own land, generally, because they want benefits from it. They want to produce income, buy it. They want to reap those benefits. On the other hand, you've got other property owners that have an interest in their property, particularly the enjoyment of that property and the use of that. Those are policy-driven decisions, and the balance has to be struck by the legislative end of things here. As a planning condition, as a Board of Adjustment, it's just your function to adjudicate those matters, those applications that come before you, and again determine whether or not they meet or they don't meet the requirements of the ordinance. Plain and simple. If you depart from that role, that quasi-judicial role, and you become legislative, then there's a prohibition against that in the Constitution. It's called the separation of powers. Our Constitution, which is our blueprint for how we govern ourselves, creates 3 separate and individual branches of government: executive, legislative, and judicial. They all have different functions. They all have different powers, and those powers can't overlap. And that's the danger here that my discussion has hoped to prompt, that you don't start crossing those boundaries when you're wearing your different hats as a Board of Adjustment, Planning Commission. I mean, that's the lesson here.
Part of our planning, and it says that we need to be concerned about the good of the community, right?